Welcome to another edition of the Mo Show Live, everybody. Hey, I'm Morris Lilienthal. Thank you for taking time to join us today. Excited to have a good friend of mine, Ron Sykstus, on today, bankruptcy attorney who is an expert in this area of the law. And unfortunately, this is something that I think a lot of people may be experiencing some financial difficulties during this COVID-19 outbreak. We know a lot of people who are seeing this or know somebody who are friends or family of them. And I know some of my clients, Ron, and probably some of your clients are in financial difficulties because a lot of their jobs are being impacted by a lot of the social distancing and closures and shutdowns that are going on in our community today. And I know that this is something that some people may have some questions about. So I appreciate you kind of impromptu making time for us today to talk a little bit about bankruptcy law and when bankruptcy would be appropriate, kind of things that you might want to try to look at doing before you file for bankruptcy, and just some kind of one-on-one that people may have some general questions about. So those are the things that we're going to be talking about today. And so let me kind of do a quick introduction of our guest today. Again, Ron Sykstus is with the law firm of Bond and Bodis. They have offices all over the Southeast, but Ron is the managing partner of the Huntsville Decatur offices. He's a University of Arizona undergrad and did his law degree at Northern Illinois University College of Law. Ron, thank you for your service. He also served in the U.S. Army as a JAG officer. And he is also host of the Next Lawyer podcast, which I
was a guest.
To be a guest, yeah. So it's kind of nice to flip the script on you, Ron.
Right.
And me be answering the questions.
I don't like the script flipped. I'll tell you that.
Well, and then the other thing is we're live. So when we did the podcast, you could edit and you could tweak in and out. So we got to mind our P's and Q's here. So folks, if you're watching and you've got questions, we're not giving any legal advice today per se, but we are just kind of giving good guidelines and factual information that you may want to know. So if you're watching live, please share this out so other people can get more good information. If you've got general logistics questions and things, put them in the comments below here. We'll try to get to them during the interview. And if you're watching the recorded version, we'll try to watch the comments afterwards. And then certainly, if you've got specific legal questions that you want to direct to Ron or another lawyer, we'd say just reach out to that lawyer, Ron's firm, and get more specifics on your particular situation. But Ron, how are you doing right now? How are things going with you and your family and your world during these trying times?
I appreciate you asking, Morris. Everything's good. I mean, knock wood, things are good right now. I think I'd mentioned to you my middle son, Tom, just got activated, active duty orders, and he has to report tomorrow, and he'll be shipping out for somewhere in the United States, I guess Wednesday. And he's a second-year law student in Alabama, so that's creating some logistical issues, but we're doing well. Thanks for asking.
Well, we appreciate your service and we appreciate your son's service. It's speaking the next lawyer up or next person up. We're really depending on the people on the front lines in the healthcare and food service industry and the grocery store industry and into the military too to do what it takes to try to get our country back on its feet. And we're so grateful for that.
Well, it's scary. And I tell folks, I mean, as you can imagine, a large part of our practice, Morris, is consumer bankruptcy, for consumers, for individuals, couples, and small businesses. And yeah, people are scared. I mean, let's face it, we're all scared. I mean, who knows what the next month looks like or the month after or the month after. And this could go on for a while. So yeah, it's scary. Go
ahead. It is. And it's scary as a business owner. It's scary as a parent. It's scary as a husband. It's impacting us like a lot of people, and we all see it from our own perspectives. I see it as a business owner with the court systems are closed down. I see it as a parent of an elementary school child who's, out of his routine and wondering when he's going to get to play sports again. And I see it as my wife, who teaches school and teaches 60 or 70 kids every day in fifth grade. And it's hard on her children and that she loves a lot and cares about. And fortunately, through awesome platforms like this, she did a Zoom call with her students last week, Ron, and had 50 some odd students on the call. And I think all the kids really enjoyed it and got a lot out of it. And I think they're going to be doing a lot more of that.
I'm sure they're craving the education and the normalcy.
Yeah, they are. Well, Ron, we've all kind of heard the term bankruptcy, but can you kind of give us a layman's term breakdown of what that is and a mindset when people come to you, when people should really consider that, not as opposed to, well, I've got some debt or there's a little bit of financial turmoil. Is that a real option? Kind of talk to us a little bit about that.
Sure. And you know what I tell folks, Morris, you want to use bankruptcy as a last resort. You don't file lightly, don't file frivolously. I mean, that will have long-term impact on you. Now, what I tell folks, if your credit's perfect, as we sit right now, I mean, that's the real issue, right? As we sit right now, but you think things are going to be tough in the next month or 2 months, you sit right now and your credit's perfect. That's what I've been telling folks. And, let's call no one's got perfect credit, but if you have exceptional credit or very good credit or,
Right.
And I really don't get bogged down in the credit scores, but if it's good, and let's define good credit or very good credit. Let's say you've never been behind on anything in the last 3 years. Now, I'd prefer longer, but I'll live at 3 years. I consider that very good credit. And when I say, never been late, not more than 30 days late on anything. If you're in that situation and we're sitting right now, unfortunately, anything you do other than staying current will hit your credit. I've not seen anything in these bills that are out there that says, hey, if you're late, then not only are we going to let you be late, but by the way, it won't hit your credit report, right? Now you can put a 100-word explanation on your credit report, but that's, you're limited to 100 words, and that's as good as the paper you write it on. So,
right.
I tell folks, I say that to say this: if your credit's good, you want to do everything in your power to stay good. And I've thought this through, and how if you're under the age of 59 and a half, if you were to hit an IRA, if you have one or something like that, I wouldn't be opposed to that, knowing that there's penalties. You got a 10%, automatic penalty and a 20% tax hit you're going to take right away. So you lose 30% of what you take. But if you think you can weather this to stay current and keep your credit good, that's what I would do, and then in a second, we'll go the next route. What if you can't,
But I think that's good advice that certainly, as we kind of said just a few minutes ago, these are uncharted waters, and for whole industries of food service industries and other service industries and things that are and big companies that work in groups, they're shutting down right now.
Sure.
But what I hear Ron saying, guys, is if you've got good credit and you haven't had a history in the last 3 to 5 years and you've maintained a good credit, haven't been late more than 30 days, then try to find any resource or revenue
you want to preserve it
to pay it. Yeah, because while bankruptcy is an option, and we're going to talk about that option in a minute, there are some bad things that come along with it, or some pitfalls or some strings that are attached that may not be a better alternative than maybe hitting your 401k or something like that, or other revenue sources.
And I don't say that lightly, because you're hitting it at when the market's down, so you've already lost money. But
Right.
to that point, Morris, I'll say this, and this is the thing that really concerns me. So you've read the studies, and they've been out, and they're all, they talk about this a lot. The news does, that 40% of people don't have, they have $400, or they can't meet a $400 bill, right? You've heard that or read that maybe. So what does this time period do? But to that point, let's say you're current on everything, haven't been behind last 3 to 5 years, great. If you fall behind on a mortgage, here's what really concerns me. And you may not have a choice, and I understand that, and we'll get to that in a minute. But if you fall behind on a mortgage, you go to refinance a mortgage, right? Or go somewhere else. Hey, I want to do something with my mortgage, refinance it, modify it. Oh, sorry, sir or ma'am, we can't do that because you fell behind on your mortgage by 1 payment, 2 payments, right? So it's almost this vicious cycle. How can I get a job if I don't have any experience, as the,
Right.
16-year-old kid? So, it's kind of a problem, and that worries me, because I don't know what folks are going to do that way. But if you start falling behind, then really, bankruptcy is an option if you can't work with your creditors. And, I do suggest to folks, try to work with your creditors first. I mean, if you start slipping behind, maybe we'll go down that road now. You start slipping behind, keep your creditors apprised of what's happening. Don't be in contact. I'd over communicate with them.
Right. Would you encourage people to do that initially with a phone call, and then maybe follow up with something in writing? Or if for example, Ron, if you've got a creditor and telephonically they said, hey, we'll work with you and get you some kind of extension or smaller payments, would you ask for that in writing, just so you got something to cover?
I wouldn't even ask, Morris. I would follow up with not only an email, but a letter. I'm an old school guy. In fact, in a perfect world, I do a certified letter. If you Morris is my creditor, if I owed the Martinson Beeson firm money and you wanted my money, and I would say I can do X, then I would follow up, dear Morris, we agreed that I would pay you X amount over this kind of time, and I'd probably do it by certified mail return receipt just to verify we're all on the same sheet of music. Because, in our world as lawyers, I mean, when you agree to something over the phone, then someone else doesn't take notes, and the next person doesn't know what was talked about. What are you talking about? We didn't agree to that. We don't do that.
She didn't have the authority to do that, right?
I talked to Ms. Jones about that 3 weeks ago. So I'd keep detailed notes. So I would keep your creditors apprised of what's going on. So you really have to watch this with. I've heard stories right now where you've heard that mortgage companies are giving a kind of a forbearance or on their mortgage. Have you heard that?
Right. Yeah.
I've heard it with mortgage companies. I haven't heard it yet with car folks or car lenders, but then I've now heard some mortgage companies have said, fine, you don't have to make the next 3 months payments. Boy, what a relief, right? Even though I told you, I think it still is going to hit your credit. And unless you had in writing, this will not be reported as derogatory information to your credit on the credit reporting agencies as the trade line. That would make me feel a little comfortable if they would do that in writing. I don't think they would. I'd ask for it. But then I've heard mortgage companies say, well, fine. And in month 4, you're going to owe us the 3 payments you're behind plus month 4. Then what do you do?
Yeah.
If they could do that, then hey, I wouldn't need to be calling you in the first place.
Yeah, that's exactly right. But I think that the good advice there, folks, is before you make the attempt to file bankruptcy or seek the advice of a bankruptcy attorney, I think the good advice that I'm hearing, Ron, is reach out to your creditors, see what your options are. And there may be more options now than there would under traditional circumstances, and then get it in writing. And whether they put it in writing or you do what we do a lot of times when I get an agreement with somebody, I send a letter to them that says, these are the terms that we agreed upon.
With negative notice, right?
That's right.
If I don't hear back from you, I will assume this is all correct.
That's right. So let's assume we've done those things, Ron. Let's assume we've contacted our mortgage company. Let's assume we've contacted our credit card company.
And let me just interrupt, Morris, because I think this is really important. But I want you to know if you fall behind, your credit's impacted. Now, and I always say this, listen, if your credit's perfect, like we've been talking about, then we're apples to oranges, right? Doing anything but paying your debt on time is going to impact your credit. If you're already behind, if you've got, maybe you're current on your mortgage, but maybe a payment behind on the car, and then there are some medical debts out there, some have gone into collections, maybe an old credit card bill is behind. Nothing, bankruptcy is not going to hurt you like you think. Bad credit, it stems from Deuteronomy in the Bible that creditors shall forgive their debtors every 7 years. That's why you hear this under the Fair Credit Reporting Act, that bad credit will be there for a period of 7 years. That's where that comes from. So you're really, in that 7-year period, believe me, it'll really be 20 years. It really won't just be an easy 7, but I'll leave that for a different, more nuanced discussion. But if you're behind, looking at a bankruptcy option is not bad. It's not a bad option because you could save your house, you could save your car. Again, I think we're in a different time period. If you had told me 3 months ago, you're 2 or more payments behind on your car, I'd expect it to get repossessed. Then a bankruptcy option, what's called the Chapter 13, which is the debt consolidation or the debt reorganization. It's a payback plan that would protect your car, would protect your house, it would protect everything you own. If you were behind on some of those hard assets, or if you were getting administratively garnished by a student loan or back taxes, it would stop all that. So there's a lot of good that can be accomplished. And again, the question always is, well, gee, bankruptcy, what's that going to do to my credit? If your credit's perfect, it's a killer. If you're already behind, it's really apples to apples.
Yeah. And so I think that's good. That's good advice too, that if you've already got some problems in the past and now things are really beginning to snowball, certainly under today's times, then, bankruptcy may be a quicker option than other times and do. And so what are your options, Ron? Can you kind of walk us through a 101 of what are as I understand that there's a chapter 7 and a chapter 13.
Chapter 13, those are the consumer chapters. But, I'll say this, and you brought this up. I don't think there's ever going to be a better time to ask kind of forgiveness or a workaround with your creditors than there is right now. If you told me this 3 months ago, I used to tell folks, people would contact me, hey, can I, hire you to negotiate with my creditors? I'm like, listen, you can pay me a lot of money. It's not going to work. You do it for free. And, you're going to get as far as I get, because they just don't work with folks. I don't understand the rationale, but, I'm not paid to understand the rationale. But now I think now is the time. If you can try to work with your creditors first, I would do that first. Now, if that fails, and what do I mean by that? Let's say, I hope this doesn't happen, but if mortgage companies start moving quickly to foreclose, because, it's like anything else. It kind of rolls downhill if they don't, if you don't pay the mortgage company can't pay their bills. I've heard some lenders say that, we've got our own problems. So, but if you start looking at a foreclosure, or your car is going to get repossessed, they're threatening to take your car, maybe you're 2 payments behind, 3 payments, if you've got a garnishment on your wages, which in Alabama, of course, is 25% of your take-home pay, something like that, a bankruptcy makes sense. As far as the different types, kind of in a nutshell, well, I also recommend look at our website. We have got a ton of information there. We have a blog that's got probably 2,000 posts, and in our search bar there, it's at bondandbotus.com, BONDANDBOTES.com. Do all the research you want there first before you talk to anyone. But there are options for you. So if you want to stop the creditors, if you want to kind of freeze your situation, the concept is this: if you file bankruptcy, Chapter 7 is a straight bankruptcy. Notably, it gets rid of unsecured debt. There is an issue of what's your relative family gross income compared to what other families in the state of Alabama or whatever state we're in make, whether you're over that threshold. But in a nutshell, it allows you to, if you qualify, you can get rid of your unsecured debt, credit cards, signature loans, medical debt, whatever's going on there. Chapter 13 is the payback plan. It's up to a 60-month payback plan where you can, if you were behind on your house and they were threatening to foreclose, if you were behind on a vehicle, if you owed back taxes, student loans, if you had back child support that's out there that you're being harassed on, you can freeze this. And the concept in its simplest terms, I don't know if you took this course, I don't know if you took bankruptcy in law school, Morris, but there are classes, some law schools offer an entire class on what's called the automatic stay, which is falls under the bankruptcy. So once a bankruptcy is filed, whether your creditors know it or not, the moment it's filed, you have this umbrella of protection. This umbrella of protection is called the automatic stay. It's found under, if you're a law geek, 11 USC 362. That's the automatic stay. That covers everything. And it's this big umbrella of protection. You are protected. Your property is protected. No one can collect on you unless they're able, through the bankruptcy judge, to pierce this umbrella, which that entails a formal motion in the bankruptcy court. So there's a lot you can do if you need it. Okay.
And are there any limitations on who can file bankruptcy? What if you filed one in the past? Does that limit your ability to file another one?
Sure, that's a good question. So we always tell folks, this probably ages me or dates me a little bit, but October 17th, 2005 is a day for us that will live in infamy, if you will. That's when the bankruptcy law changed. So what that said was, if you file a Chapter 7 now after that particular date, which when we tell folks, again, for us, it's like yesterday, but that I know it's a long time ago. If you file a Chapter 7 now, you're prohibited by law from filing one again for a period of 8 years, okay? And more importantly, if you have a Chapter 7 discharge within the last 4 years, you can't file, if you file even a Chapter 13, so it's kind of called this Chapter 20, if you will, 7 plus 13. But you file a Chapter 13 within 4 years of a bankruptcy discharge, a Chapter 7 discharge, you're not entitled to a discharge. So you can stop your creditors, but at the end of this 5-year payback plan, you've got an issue with your creditors, potentially. So there's kind of nuances there. So we always check with our clients. I mean, we look it up. There's a universal bankruptcy database. We'll look at the previous filings. We calculate the dates. We see, what you can or can't do. But you just kind of want to be aware of that. So if I had my choice right now, I'd probably file, if you're looking to do anything, I'd probably file a Chapter 13. And I say that for this reason. If you file a Chapter 7, you're in, and you don't have the luxury to get out. And what I mean by that, what if you file, someone says, hey, yeah, you can file, but it turns out you have too much equity in your house that you can't protect it all. The trustee can say, well, I'm going to take your house and sell it and use what I can make, pay back your creditors. Well, no, I've made a mistake. I don't want to do that. Too bad, you're in. So I'd be very careful about that. And the other thing that concerns me right now about a Chapter 7, who knows what the next month looks like, or 2 months. And I say it in this context, Morris, if you file a Chapter 7 today, what happens tomorrow? Let's say let's say you don't have health insurance. You walk out, let's say out of your office. I was going to say my office, but let's say you walk out of your office, slip on the sidewalk, break your leg, no health insurance. You've got a $20,000 bill. Well, you just filed bankruptcy yesterday. Future debts, you're on your own. So you're on the hook for that. Now, if you file a Chapter 13, you always have the option of modifying a plan or getting out. In a Chapter 13, you can file it and you have an absolute right to get out. You can voluntarily dismiss your case. You can also change your case over to a Chapter 7. So in that context, and again, I don't want to get too much in the weeds, but in that context, you file a Chapter 13 today at your office, and then tomorrow no health insurance, you fall, break your leg, you can change to a Chapter 7 and add in that debt, because that debt will, subsume the previous debts.
So in short order and from our viewers' perspective, a Chapter 13 is the payment plan, where a payment plan set up to pay off your creditors. And you have a lot more flexibility under that plan to reorganize and add in if some new unexpected debt comes in. You have at least the option or availability, whether it's granted.
You have availability to do movement. And I'll say this to you, Morris, as well. And I do a lot of security clearance work. We have a website, securityclearancedefenselawyer.com. I get so many people that come to me that have clearances that fall into debt. And that's the number one reason why people lose clearances. Now, as I always tell folks here, if you lose your clearance here, I mean, you and I are lawyers, fortunately, or unfortunately, but if I didn't have a clearance, or if I wasn't a lawyer, I'd need a clearance here to make the kind of living I need to make to take care of my family. So if you lose your clearance, it's everything here. So financial issues are the number one reason why people lose clearances. So what I always tell folks, if you have debt problems and you have a clearance, look to file a Chapter 13 where you pay back your debt in full. It's pretty fail-safe. And there's a way I have folks notify your facility security officer, your FSO. We do that once it's filed. You won't have a problem. I mean, it preserves your clearance. So it's a big deal.
Well, we'll put we've already put a link. I put a link in, Ron, to your firm's website where people can check information and do some research there on some of the things we've been talking about. And then, it's so true here that I get that a lot of times. People who have security clearance have a lot of questions if they're going to be in a case that I'm going to be representing them in litigation, as to how that's going to affect them, and they have concerns about that. And I can, because I don't do bankruptcy law, but I can see how that would be a big issue for them. And so we'll put a link there to that website as well for people to get more information.
And I hope you don't mind me. I'll get in the weeds just for a second with this, because it's such a big deal here so with clearances, there was a change in the law. And folks who have clearances know what I'm about to say, or will be familiar with this concept. If you have a secret clearance, which most of that's probably 90% of the employees here have secret clearances, and those are renewed every 10 years. You have to fill out the form. It's called the SF-86. You do that online under this eQuip system. It's the form they used to use, and they still call it that. But you fill it out online. You answer all these questions about your debts. Top secret, you have to renew it every 5 years. You have to fill this form out. However, this past summer, change in law is this: the government and everyone will within the year be on this 24/7 automatic reporting that your credit report is available to the government 24/7. So they're going to know the moment you have a problem. Here's the other kicker, and it's kind of this nuanced issue. If you have a problem, you have to self-report. So I know your firm does a lot of different type of work. You get a DUI, you better report it to your facility security officer, toot sweet, or you're going to have a problem. The problem is, yeah, we don't mind. So we understand you're explaining the DUI and what happened. You didn't report it. You know it's self-reporting. Same thing with debt. So if you have debt, they're already seeing it. Do you self-report? Do you not? So it's kind of it's a tricky thing.
Yeah. And those are concerns that for a lot of people here that are people may still be having now. And like we said, just starting out, let's hope that those people everybody gets back to work quickly.
Sure,
and
absolutely. That's what we all want.
That's what we all want. But again, if you're just joining us, our guest today is Ron Sykstus. He's the managing partner of the Bond and Botus firm here in Huntsville and Decatur. And we're talking a little bit about bankruptcy law, but what we've kind of been talking about is that is a last resort, and is to try
Absolutely.
to find ways to work with your creditors or look at other avenues. As much as you hate to say it, if you've got really good creditor, if we said almost perfect credit because nobody has perfect credit,
right,
going into this and using other avenues, and that if you've had some problems in the past and your credit score is not where you would want it to be, then bankruptcy may be more of a viable option for you. If you've got creditors, looking at repossessing your home or your car or something like that. Ron, I guess a question that a lot of people have, and they had this for us and whatever practice area we're practicing and representing people on, and the elephant in the room is if I'm having financial problems right now due to the ongoing pandemic, and I can't afford to pay my bills, how can I afford to pay a bankruptcy lawyer? And I'm not asking for what your fee schedule is. I'm just asking in general, how does a bankruptcy attorney get paid? Is it a flat fee? Is it an hourly fee? Is it upfront? How does all that generally work? So people just have
sure. As a general rule, more so, we always tell folks, again, we require a free consultation. I mean, you don't have to come in with any money. And right now during this, we're all going to start working remotely Wednesday. As far as meeting with clients, we're not meeting with them in person, but we're doing everything by phone, video. We'll meet you however you need to meet us. Let's talk for free. We don't have to even talk money. If we start a bankruptcy case, we start with $100. We're creative when we work that. We'll kind of talk it through, but that's how we do it. We start a case for $100. But again, let's just talk. I always tell folks, usually if you came to my office, I'd give you a cookie and a water bottle, but now you have to do that yourself at your home. But let's just talk and see what's going on and see what makes sense. Again, we do tell folks, like you said, let's use it as a last resort. Let's see what makes sense. And then there are some things, like I said, that trigger people. You get a notice of a foreclosure, you better talk to a bankruptcy lawyer immediately, because we can stop that. Alabama, unfortunately, is the fastest state in the union as far as a foreclosure. It's a non-judicial process where, like Florida, if you want to foreclose on a home, you go through court process. That's probably a 2-year deal. Here, 6 weeks start to finish. So it's lightning fast, and all they have to do is publish it 3 times in a local newspaper, issue you 1 letter by certified mail, which they don't really have to do that, but they should. And then they foreclose. So if you get a notice like that says they're selling your house on the courthouse steps on a particular date, talk to us, talk to somebody.
Yeah, and that's a good point. And, we have people that call us all the time, and sometimes I'll tell people I don't think they need a lawyer for that, or some people are just kind of wanting some information. But what I gather, Ron, and my experience with bankruptcy matters as an injury lawyer, when I've had clients who are in the middle of a bankruptcy and I have to get approved by the bankruptcy court, those hoops that we have to, as trial lawyers, have to go through sometimes. Bankruptcy is not something that I think you need to try to go on your own, right? I mean, this is something, if you are in the situation that we've been talking about the last few minutes, that you're to that point where you think that is a really an option for you under your circumstances, then I would really encourage you to find someone like Ron or Ron's firm or someone else in your community that's got experience with bankruptcy law and hiring them and finding a way to do so, because I don't think that's something you want to go on your own.
Just by you saying that, Morris, how about this for a requirement when they changed the law, October 17, 2005? Here's a new requirement. You have to go through credit counseling. What does that mean and what do I think of it? I'll leave that for another day, but you can probably hear it in my voice. You have to go through credit counseling. A lot of people don't know that. So you file your bankruptcy petition thinking you're going to stop a foreclosure or stop your car from being repossessed. You didn't get this certificate, right? So now there's a jurisdictional defect in your bankruptcy. It'll be dismissed like that. And then you've created a big problem, because then if you have to refile a second bankruptcy filing within a 1-year period of a dismissal is a big problem. A third bankruptcy filing within a 1-year period of 2 dismissals is a huge problem. So it's complicated, and it was made complicated by this change in law, way more complicated than it was.
Ron, talk to me a minute about what's going on with the court system, with the bankruptcy court system. And folks, if you're not familiar, Ron and I both practice here in Huntsville, Alabama. And from a state court perspective, the state courts are kind of closed down from in-person meetings. Jury trials have been continued, but we have an electronic filing system, folks, and we're still able to file things. And some judges are allowing telephonic or even video conferences, and some judges are a little more old school and trying to wait and see if we could, move hearings back. But Ron, what's going on in bankruptcy court?
Sure, that's a great question, Morris. No, our system, I'm really proud of the system we're in. So bankruptcy is it's a federal law. So every location there's a bit of local flavor, but it's a general federal law, throughout the land, as far as the coverage. So our court system, and most systems are like this. First of all, we have electronic filing. That's mandated. Anything you do, you file electronically. So we can do that from our office or even from our home. Secondly, our courts, jumped on this right away. So our court system, everything is set up by phone. So all the hearings right now are by phone. So there's 2 types of hearings: court hearings. If one of these creditors wants to try to, break into that automatic stay or pierce the automatic stay or something like that, those are by phone. 341 meetings, what they're called, is the meeting of creditors, which is the one time the folks have to show up, those are done by phone right now. So it's been pretty seamless as far as that. So I've been very proud of this. It's really impressive what our court system has done.
Well, that's good news to hear that essentially the courthouse is still open in the bankruptcy system, and it's, for the most part open in the other systems here. It's just with jury trials being put off, and some things can be heard, some can't. And, from our trial perspective, it's hard because now how do you handle depositions and dues? Sometimes you can do, some people are more available. We're trying to set some up remotely like this, where our clients don't even have to come to the office. They can be at home and log in and do, but they're trying to make sure everybody has appropriate, technological capabilities. Can be difficult.
And Morris, you mentioned, I know you do a ton of personal injury. I know that's your specialty. I know you do other stuff, but that's really a lot of what you do now. And you'd mentioned sometimes you'll have cases where someone has filed bankruptcy, you have a PI claim. Just to talk about that, because that's such a hot button issue. So if you file bankruptcy, you have to disclose all of your assets, everything you've got, transfers of property, any potential cause of action or pending lawsuit against anyone. If you don't disclose it, you lose. So if someone files bankruptcy with me and they don't say they're represented by Morris on a personal injury claim, a car accident claim, a trucking case, whatever, and they don't, we have a 1-page, you best fill this out. If you don't, it's over. And we have folks sign off on that. And some people think, well, I'll be creative. I don't need to tell them about that. A smart defense lawyer says, hey, they filed this bankruptcy petition where they were supposed to list everything. They didn't list this. This trucking accident case should be dismissed, and it will be dismissed. Huge, huge deal. So believe me, we're on top of that. We don't want you to lose that money.
Yeah, it's an important topic, and we certainly try to do our end and due diligence as well for our clients to protect them. Ron, I guess one last little quick question I had, and you kind of hinted at this at the beginning of the conversation, but I hear a lot of commercials on satellite radio, and I've heard seen some on TV about debt consolidation and credit card debt over $10,000. Is there any real validity to that? Is that something, if we're in this predicament where you're saying, hey, we need to look for alternative ways of trying to pay before we file bankruptcy, is that something that we should really look at, or should be a little leery of that?
What's funny about it? We talk about this all the time. So the commercial is, if you just filed bankruptcy, you want to turn the radio off. I'm about to tell you the secret that the credit card companies don't want you to know. Of course, I've been practicing consumer law for almost 30 years now, since I've got out of the Army. I don't know what the secret is. And believe me, I've studied this stuff a lot. But believe me, I hear that sounds pretty good to me, right? There's sometimes I'm thinking maybe I should call. But, it's if it sounds too good to be true, it is, right? So here's what happens. These companies take, so if you contact me and I'm going to, quote unquote, consolidate your debts, you're going to pay me a fee right away. I'll take a cut of it. We'll park money into an account and I'll try to negotiate with your creditors. Here's the dirty secret. It hits your credit every month. So every month, so you pay your Citi card $100 a month. Well, you're now only paying $20 a month. So that month on your credit R1, month 2, when they only get the 20 R2, you're at an R9, your credit's devastated before you can turn around. All your creditors don't have to agree to it. It hits your credit. You'll still get calls. So what have you accomplished? And then one last thing, and this drives me wild. Under that scenario, let's say you ended up paying Citi card $1,000 when you owed them $4,000, and that your magical company worked that out, right? So here's what's happened. Not only has it hit your credit, devastated your credit, the $3,000 you saved, they issue a 1099 to the IRS for this forgiveness of debt. So you now have this phantom income of $3,000, quote unquote, you made that you're not going to pay tax on. So it's a mess.
Oh, wow.
We have a blog post. In fact, there's a good lawyer out of California. He made a kind of a good YouTube video talking a lot about this. I think it's a February blog post we have out there by my partner, Amy Tanner, that talks about debt management companies or debt relief companies and stuff you need to know. So look at our blog and you'll see that, and just, do your research. And here's what I tell folks. If you're adamant about using that type of company, do 2 things. Make sure in writing, and I want that in writing from them, they guarantee all your creditors will agree to it and that it will not have any derogatory impact on your credit. If you want to try it that way, I still think it still makes me queasy, but I'd be a little more comfortable.
That's good advice, real good advice. Ron, thanks so much for your time today. I've put in the show notes below here, folks, a link to Ron's website. A lot of good resources there. Ron, I also know you've got a book out there that you might want to give our followers today.
Yeah, we do, Morris. It's called Bankruptcy. We wrote the book on it. It's available for sale at Amazon. There's a link at our website, but I'll tell you what I'll do for listeners of the Mo Show and viewers. I always tell folks I got a face for radio, right? But there is, if you'll send me an email and I'll give you my email address, just put Mo Show Book. So Mo Show Book. I'll know what you're talking about. I'll send you a free copy, an e-copy of the book. Save me the postage, but I'll give you an e-copy. It's called Bankruptcy. We wrote the book on it. It's everything I talked about right now. And I like to think it's very easy to read. And it's, everyone has 2, 3, 4 real concerns. Those will be addressed in that book. So happy to send it. So send me an email, Ron, R-O-N, at bondandbotus.com. That's Ron, R-O-N, at BONDANDBOTES.com. If you want to put a link to that email, Morris.
I'll do that.
Yeah, and just put free book for Mo Show listeners. Put Mo Show book in the subject line. I'll just respond to that. I'll send you a book. And that way, that's another way for you to do your research. It's a lot of that's at our website, but it's a little more easy, condensed way for you to kind of figure out your own situation.
Awesome, Ron. Thanks so much for being kind and offering that resource to folks out there that may need it at this really
it's fine. And they don't have to pay for it this way. It's just another free resource. Just figure out your situation.
That's right. Well, folks, thank you so much for taking time to watch the show. And Ron, thank you for all the good feedback and advice that you've given our viewers today. And we certainly hope and pray that this predicament that we all find ourselves in from a health and financial situation gets better sooner than later. And we certainly wish you and your family and all of your staff and lawyers the best during these uncertain times.
Same to you, Morris. Again, it's always enjoyable working with your law firm. You and your firm are very well respected. You guys have been doing great work here for decades.
Well, thank you so much. It's very flattering, and we enjoy working with your firm as well. Thanks, everybody.